Good morning, good afternoon, good evening, wherever you may be listening to us from. My name is Stuart Kemp. I'm the Deputy Chief Operating Officer of WADA. And with me today is Ben Sandford, who is the Chair of WADA's Athlete Committee. Ben is a three-time Olympian in the sport of skeleton, a World Championship medalist, and not only the Chair of WADA's Athlete Committee, but also a member of WADA's recent code drafting team, as he is an attorney himself in Rotorua, New Zealand. Today, Ben is going to walk you through the Athletes Anti-Doping Rights Act, which has been an initiative of WADA's Athlete Committee over the past couple of years. I will pass to Ben shortly, but just let you know that following Ben's presentation, we'll have an open Q&A where Ben and myself would be happy to take any questions you may have. And at any time during the presentation, if you'd like to put your questions in the chat box, I'll be able to moderate those questions following Ben's presentation. So thanks for joining us today, and over to you, Ben.
Thank you very much, Stu, and again, welcome to everyone wherever you are in the world. It's very late at night or very early in the morning here in New Zealand, so I hope you're all well in these rather extraordinary times. So today we're going to be, as Stu said, covering the Athletes Anti-Doping Rights Act, and we've put this webinar together as part of our webinar series for athletes all around the world. So we really do hope you find it both interesting and informative. And Salva, if you can move on to the next screen. So Salva is going to be doing the technical work behind the scenes here, changing the slides and making sure it all works. So you'll hear me asking Salva every now and then to change the slides over. So what we thought would be good to cover today would be the past situation. So what we had in the past in terms of athlete rights. We'll then move into doing a review of the Athletes Anti-Doping Rights Act. We'll look a little bit at remedy after that. It's always important to have some sort of remedy if we're talking about rights. And then there's 2 3s there. Sorry about my not counting that correctly there. And then we'll move on to what's happening in the future. So the past situation. So a few years ago, we found ourselves in a situation where rights within anti-doping and athlete rights within anti-doping were scattered between the code and the international standards. So as you know, the code, the World Anti-Doping Code, is the fundamental document which underlines all anti-doping rules. It's the baseline for everything that we do in anti-doping. And that periodically goes through a review process. And then we come out the other side of that review process with a new code. So the last code, the code that we're operating under now, is the 2015 code. And we've been through a review of the code. And that's a worldwide review. It's open to anyone to make comments and propose ideas for how the code can be changed and improved. So that came to an end at the end of last year, and the new code was adopted. And so we have a new code from January the 1st, 2021. We also have 8 international standards. So the international standards are the rules for all sorts of things from TUEs to the prohibited list to result management. So these govern particular areas within anti-doping. So between these 9 documents, athletes have rights which are scattered between them. But there was never anywhere where athlete rights were centralized and in one place. Our responsibilities were centralized. There was a special part of the code which spoke about the roles and responsibilities of athletes. And then, as I'm sure you're all aware, there are hundreds and hundreds of rules in anti-doping about what athletes have to do, what we're required to do and how we're required to do that. But there was no one place where we could find our rights. So what we've done is we've tried to create a central resource. So this will be something that you'll be able to refer to, you'll be able to look at and know that those are the rights, these are the main rights that you have within anti-doping. And because the rights were so scattered, it was actually quite difficult for athletes to work out what their rights were. So there was often quite a bit of misunderstanding or misinformation about what an athlete could or couldn't do, because those rights were, not buried, but scattered within thousands of pages of legal text to do with anti-doping. At the same time, in the last couple of years, we've seen a real sort of renaissance of athlete voice and representation. So athletes have been, standing up, asking for more rights, and in anti-doping, that's translated in a number of ways. And so the athlete voice has come through loud and clear that, athletes want to know what their rights are, they want to know where to find them. So what we did as an initial response was we started to work on bringing those rights into one document. And out of that, we get the Act, which we are presenting today. So this is the Athletes Anti-Doping Rights Act. And we developed this through consultation. So as I said earlier, the code consultation was happening during this period, and so we really tagged this onto the side of the code consultation in terms of timeframes. So over 2 years, we consulted with thousands of athletes and stakeholders within anti-doping, and out of that, we developed the Athletes Anti-Doping Rights Act. And it's got two main parts to it. So there's the first part which deals with existing rights, and then we've also got the second part which deals with proposed athlete rights. So the Act, after working on it for 2 years, it was approved last November when we were in Katowice, and it's there right now, but I would say it becomes applicable from the 1st of January, which is in line with the World Anti-Doping Rights Act. With the code and the international standards, and that's because the Act refers specifically to sections of the code and the international standards which start on the 1st of January. So moving on to the Act specifically. So we start the Act obviously by saying what it is and what the purpose is. So the purpose of the Act is to ensure that athlete rights within anti-doping are clearly set out, accessible, and universally applicable. In the preamble, we go in to describe what the Act is and how it works. So we talk about the World Anti-Doping Code, the World Anti-Doping Program, and about athletes' fundamental right to participate in doping-free sport, and thus to promote and protect health, fairness, and equal opportunity. We reference the code and the international standards, and we say how the Act has come to be through extensive consultation with athletes from all over the world. We also say that not every single right that you have as an athlete in terms of anti-doping is in this Act. But what we found through our consultation was there were athletes that wanted their main rights, the ones that they would refer to the most, which they would use the most, which they value the most, put into one place. So the main what I would say the most important rights within anti-doping are here within the Act. And on that point, it's also important to note that this isn't every right that you have in a sport context or in your life, in a human rights context. This is very much limited to just the rights that you have within anti-doping. So the Act was approved by the WADA Executive Committee, and it came into being at the end of last year. And so, as I've said already, it's made up of two main parts. The first part of the Act, part 1, is rights. And these are the rights that you have. These are the rights that exist within anti-doping. You don't have to ask anyone for these rights. They are there, and these are what you have. So we thought it was important in the first part to say exactly what you had. And again, this isn't every single right, but it's the ones that, after consulting with athletes, that were deemed to be the most important. So we start off the Athletes' Rights Act with equality of opportunity. And this is something that always comes up when we're talking to athletes and when we're talking about anti-doping, is that athletes want to be able to pursue sport without doping, and they want to be able to be part of clean sport, and they want it to be fair, and they want the same rules to apply to every athlete around the world. So we articulate that in equality of opportunity. And that's also very similar to having equitable and fair testing programs around the world. So athletes want to know that the anti-doping program is working around the world, that the same rules that are applying to them are applying to everyone else in the world. So we're just sort of outlining the basis in the first two articles. In Article 3, it starts getting a little bit more specific. So we're talking about medical treatment and protection of health rights. So athletes have the right to be free from any pressure that jeopardizes their health, be that physical or emotional, through doping. Athletes have the right to obtain a therapeutic use exemption. And it's really important that athletes do know how a therapeutic use exemption, so a TUE, how that works, and where they would go to access a TUE. So what we do throughout the Act is you'll see we've flicked over here. So in rights to justice, for example, at the end of the paragraph, and if you go look at rights to justice at the end of paragraph 2, we actually cite where you'll find that actual right within the code and the international standard. So that's important if you're looking through the Act and you want to know exactly where that right is within the volumes and volumes of anti-doping rules. You can go to, in this instance, Code Articles 8 and 13, and also the International Standard for Result Management. So health was an important one to have in the Act. And right to justice, number 4, is also something that has changed a lot under the new code, and I think it's something that we need to really emphasize because there has been, I think, a really big step forward for athletes in this regard. So what's happened is we have a new international standard for result management, and that changes, I think, the level of fairness that athletes will generally feel around the world in terms of their initial hearing and their appeal hearing. So now both of those will be much more independent, and out of that there should be a lot more fairness for athletes as they move through that process. So as it says here, athletes have the right to justice, including the right to be heard, the right to a fair hearing within a reasonable time by a fair, impartial and operationally independent hearing panel with a timely reasoned decision. On appeal, so that's your first level. That would be, if you're accused of breaking the rules of an anti-doping, or there's a adverse analytical finding, you would go to your first hearing. Then on appeal, there's even a greater level of independence. So on appeal, an athlete has a right to a fair, impartial, operationally and institutionally independent hearing panel. The right to be represented by counsel at the athlete's own expense, and a timely written reasoned decision. And that's different from what exists now. So what we've seen in the past is often an athlete might be accused of something, they might be investigated, and the person or the body that is investigating them is also the hearing panel, and then the appeals panel is maybe part of the same organization. So that is no longer possible anymore. And so what we'll see is, far greater independence from panels, especially on appeal. The right to accountability is number 5. Athletes have the right to make sure that anti-doping organizations that has jurisdiction over them are accountable for their actions and omissions through the compliance system. And so WADA is the global regulator for anti-doping, and as part of that, it is their job to make sure that anti-doping organizations are following the rules that they need to be. And this is something, again, that is really increased in recent years. So WADA has a compliance department, and every day, all year, they're there monitoring and making sure that anti-doping organizations around the world are following the rules that they should be, and making sure that the sport that we're taking part in is fair and clean, and making sure that the anti-doping organizations are doing the jobs that they should be. On to number 6, whistleblower rights. One of the things, again, that we've seen in recent years is the importance of whistleblowers. And in the code that we have at the moment, in the 2015 code, there's actually no protection for whistleblowers in there. And we really want to encourage athletes and support personnel to come forward with information about doping. And so if we want to encourage people to come forward and be a whistleblower and provide information, we need to make sure that our rules also offer protection to those athletes to do that, and that they can do that without fear of repercussion. So we now have, in the code, we have rules that articulate that athletes have these rights to these protections. And so in the Athletes Anti-Doping Rights Act, what we're doing is we're articulating what it's saying in the code in Article 211, so that an athlete can come forward and they know that if someone tries to prevent them, or someone tries to have some sort of impact on them as a result of that, then that person can also be sanctioned under the code, so the athlete has more security to come forward. We move on to number 7. When we were doing our initial consultation with athletes, we didn't have the right to education in there, and it very clearly came through straight away that athletes wanted this right to be articulated within the Anti-Doping Rights Act. There's now a new international standard for education, which means that anti-doping organisations need to follow certain rules and establish certain procedures for how they deliver education and who they deliver education to. So one of the things, that education is a huge part of anti-doping. Athletes want to be following the rules, they want to know what the rules are, and to be able to do that, they need to be getting education. So articulating that right, that we as athletes have the right to get education. And there's a number of ways that athletes can get that education, and we're always happy to direct athletes to where the relevant education is. And if you're wondering about where it is, there's a lot of that on the WADA website, and also with your anti-doping organisation, maybe in your country, or with your international federation. There's a lot of education resources out there, so please have a look. The right to data protection has become really important in recent years, and there's also a new international standard, or the standard has been updated and improved, and so we needed to re-articulate the rights that athletes have in relation to their data protection. So anti-doping organisations obviously do store information about athletes, but there are limits to what they can store and how they can store it and how they can use it as well. So that's all information that is in the international standard, and so we've basically taken an overreaching snapshot of that and put that into Article 8. The right to compensation. This is something that has always frustrated me in the past, is that the rule at the moment is that, let's say athlete A wins the Auckland Marathon here in New Zealand, and they win $100,000, then their sample comes back positive, that athlete has just disappeared, then there's no, and somehow let's say the anti-doping organisation manages to prosecute that athlete and get the money back, you would think that that money goes to the athletes that finished second or third as they get their medals upgraded, but the current rule doesn't say that that will happen. So the current rule allows the anti-doping organisation to keep that money. So what we've done is we've managed to increase the athlete rights in this instance, and so now the money that is recovered by an anti-doping organisation can be redistributed to athletes. It is difficult for anti-doping organisations to get that money back, and I think that's something we need to be clear about. The money, as you would imagine, doesn't just automatically come to the anti-doping organisation, and it can be really tricky for an anti-doping organisation to get that money back. So I wouldn't expect anti-doping organisations to be chasing athletes around the world through court battles trying to get that money back. But even through the sanctioning process, it can be part of the sanction that the athlete has to pay that money back. And at least this is a step in the right direction where the money can be, if possible, redistributed to the athletes that rightfully deserve it. Protected person rights. So minors and protected persons. Protected persons is a category within the code and anti-doping rules now that covers minors and people that lack the capacity to make decisions for themselves. And so there are special rights in relation to minors and those people. And so we need to make sure again that those rights are clearly articulated so people are aware of those rights and when they apply and how they apply. Moving on to 11, rights during a sample collection session. There's often a lot of confusion around what rights an athlete has during a sample collection session. And we've seen some pretty big legal cases which sort of turn on what's happened in a sample collection session. And there's a lot of rules in the international standards and in the code about sample collection sessions. And so what we've tried to do here is, articulate that in one paragraph. So when subject to a sample collection session, an athlete has the right to see the identification of the doping control officer, the right to ask for additional information, the right to be informed of the authority under which the sample collection is being conducted, the type of sample collection, any conditions that need to be adhered to prior to the sample collection. You have the right to hydrate unless they have provided a sample that does not meet the requirement for suitable specific gravity, and so on. So you do have rights in sample collection. It's really important to know them so you don't find yourself in breach of any of the rules which you also have to follow. So make sure you know what's going on before you get into sample collection. The right to B-sample analysis. B-sample has always been quite a sacred sample for athletes, and it's there as a backup. So if an athlete's A-sample does test positive, the athlete can request their B-sample analysis. And so again, we articulate what the rights are around B-sample analysis here in the Act. So rights, Articles 1 through 12, those are what I would say are your main rights within anti-doping. We then have 13 and 14, which we need to put in there, I would say, sort of for legal reasons and to make sure that athletes know that your other rights and freedoms are not affected by anything in here. And also finally, application and standing, that nothing in this Act changes the code or the international standards which we all have to follow as athletes. So what we're doing within the Act is articulating the rights that you have within the code and the international standards. Then we move on to part 2, which is recommended athlete rights. So these are rights that we don't universally have as athletes. And through the consultation period, athletes were really strong on the point that they didn't just want the Act to be a document which articulated their current rights. They also wanted it to be aspirational. They wanted to say these are additional rights which we might not have universally through the code or the international standards, but we think are really important to clean sport and to athletes. So as you can see, if you're reading through this, they don't exist all around the world. They might exist in some countries and some anti-doping organisations, but not everywhere. And so we've identified 3 of these rights: the right to an anti-doping system free from corruption, obviously you don't want your anti-doping organisation to be corrupt in any way, and we've seen some pretty horrible examples of that. So we're really encouraging anti-doping organisations to adopt some sort of anti-corruption policy. Some of them do at the moment, but we think it's best practice, and we think it's in athletes' interest and in the interest of sport that when it comes to anti-doping, that there are rules that prohibit corruption. The right to participate in governance and decision making. And there's been, a lot of calls within anti-doping for increased athlete representation. We currently have a working group within WADA, which has been set up by our WADA Athlete Committee, working through increasing athlete representation within WADA. And I think whenever you have an organisation that is making rules that you have to follow, they're making decisions about how you can act and what you can do, and in relation to sport in particular, it's really important that athletes are part of that process. If someone's making rules that you have to follow, you should be able to input into those rules, and you should be able to have a say in that organisation. And so that's what we're trying to articulate here, is that we need athletes to be part of the anti-doping system. And personally, I think that anti-doping organisations, when they have strong athlete voice and when they have that input, are much better off. It's much better off that we're all, you might want to say, sailing in the same direction and on the same page, than trying to achieve different things. And then 17 is the final right that we believe that should be adopted as well, and it's the right to legal aid. So through the result management process, one of the things that has often come up is that suddenly an athlete has broken a rule or is alleged to have broken a rule, and they're suddenly having to learn entire new language, know an enormous amount about anti-doping, just to sort of get through that process. And it can be a very frightening process, and it can be quite a daunting process as well. And the right to legal aid creates a little bit more balance in that struggle or in that time of need. And so what we're encouraging is that anti-doping organisations, through whatever mechanism works for them, provide legal aid to athletes. And by doing that, athletes can get the right information that they need at the right time to represent themselves in the legal process. So that's the Act. And now I wanted to move on and talk about remedy. So we've spoken about the rights that you have, and also the rights that we're encouraging anti-doping organisations to adopt. But it's also really important to know, if you have these rights, where do you go when someone or an organisation breaches those rights, or you believe that your rights have been impacted? So there is no point in having rights without remedy. If there's no remedy, then the rights are rather hollow, and you're really relying on the goodwill of, in this case, the organisation or another individual to recognise your rights. So I presented a webinar earlier in the year to anti-doping organisations on the Athletes' Rights Act, and a lot of that was about what athletes' expectations were, what the sort of aim of the Act was in relation to how the Act would be implemented, and what anti-doping organisations would need to do in this space. So, and this is quite new for a lot of anti-doping organisations as well. So I don't think it's going to be perfect everywhere on the 1st of January. And I think it's going to be a learning process for everyone as athletes have a better understanding of their rights, as anti-doping organisations and WADA learn how athletes are coming forward to them to ask for those rights to be respected, or with issues around things that have happened. So there will be a learning process here, and that's good. It's good that we can continue to try and improve the system. So there needs to be a mechanism for athletes to report issues. Athletes need to be heard and not ignored. And what will happen if an athlete highlights a serious breach of one of their rights, and what are those corrective actions? And then if an anti-doping organisation adopts part 2, there also needs to be effective, sorry Salva, can you go back just a second? If an ADO adopts part 2, there needs to be effective and accessible policies in place. So that would, when I was talking about the anti-corruption policies or the legal aid, if an anti-doping organisation adopts those, they actually need to be offering those as well. So, you know, it's one thing to say something on paper, but a completely different thing to actually be doing it in practice. So we need to make sure that both of those are happening. You can change over now. Yeah, thanks. So continuing on this theme, as I said before, there's been a real focus on what athletes have to do with an anti-doping. And if you ever find yourself reading the code, you can see that in the code, and the fact that there's an entire section in the code on the roles and responsibilities. There's also generally been a real big focus within education on telling athletes what they need to do with an anti-doping. You know, you need to follow these rules, you need to fill out your whereabouts in this way, you need to go through sample collection in this way. These are what we have to do. And there's a lot of responsibilities that athletes have in anti-doping. And generally athletes are really fine with, and maybe not happy, but athletes are content to follow those rules as long as we know that the system is working, as long as we know that as a result of that, we're able to compete in clean, fair competitions. So what we're doing here is changing the dynamic a little bit of what we're telling athletes and what we're articulating to athletes. So instead of just saying, these are all the rules and responsibilities that you have, we're also now turning around and saying, with an anti-doping, these are the rights that you have. So as it says in point 2, we're highlighting what rights athletes have in the system. And we need to ensure that we have appropriate mechanisms to support these rights, as good as the mechanisms we have around enforcing the rules and responsibilities at the moment. And so specifically moving on to remedy, where do you go and what do you do if one of your rights is affected? And this is important because if you do feel like one of your rights has been affected, it's not just enough to know that it's been affected. You also want to go somewhere, report it to an organisation, and see some sort of remedy or outcome as a result of that. And so that's been part of the work that we've spoken to anti-doping organisations about, that they need to be able to, you know, listen to athletes, they need to be able to hear from athletes on these issues, and they need to be able to take steps to address these concerns from athletes. The other part of this is that WADA is the global regulator in anti-doping. So if an athlete has a real concern that one of their rights has been affected, they have the ability to go to WADA, and WADA runs its compliance program. And you know, these are rights that exist within anti-doping, and an athlete has every right to go to WADA and report an issue and say that this is a concern to them and what's happened to them. And then that can feed into WADA's compliance program, which they run of anti-doping organisations around the world. There's also, I think in here at the moment anyway, a role for athlete committees to play, whether they're athlete committees within your anti-doping organisation or us as the WADA anti-doping, sorry, the WADA athlete committee. And I think if there's a concern at the moment, or in the next short while, in relation to rights and in relation to what WADA is doing as the global regulator, then I think bringing that issue to the WADA athlete committee, and then we can look into it and discuss that with WADA and be able to report back to you. And lastly, it's the ombudsperson. And so I don't think the system that we have moving into next year is a perfect system. I think it's a system that we will learn from and adapt and make better as we move through this process. And one of the things that we're trying to do to make it better is introduce an athlete's anti-doping ombudsperson. And this would be an office or offices, and there would be an ombudsperson or ombudspersons that you would be able to go to, to report that your rights have been affected in some way, that they've been breached in some way, that you have some concern about them, and the ombudsperson would be able to look into that. They would be able to report on that, and they would be able to make recommendations on that. So at the moment, that's sort of having the ombudsperson there is sort of the last piece of the puzzle that we need to get into place to make sure that there really is some sort of effective remedy in place for athletes. And that wouldn't just be in relation to athlete rights, but any sort of issue that athletes had concerns about in relation to anti-doping, and they didn't feel comfortable going to their anti-doping organisation. So that's work that we're undertaking at the moment, and hopefully next year we'll have completed that and we'll be able to roll that out. Moving on to the future. So as I've said already, this isn't a static document. It's something that is going to need to change. The Act is there, it's there right now. So you have these rights now, it exists. And anti-doping organisations, as a result of all of this, are having to adapt as well. And so I've put this slide up just to sort of highlight some of the implementation that your anti-doping organisation might be undertaking sort of behind the scenes at the moment. And so an anti-doping organisation, they don't have to adopt the Act. And I say that because it's already there. There's nothing necessary for them to adopt, because the first part of the Act is rights that you have. So it's already adopted by your anti-doping organisation. The second part, however, an anti-doping organisation would have to adopt, because those are rights that you don't have. So what we're seeing is some anti-doping organisations will adopt Part 2 in full, some are picking and choosing, some just can't offer all those additional rights at the moment. And especially legal aid is tricky for some anti-doping organisations because of the legal structures in their countries. But a lot of them are doing work to make sure that athletes have those additional rights. And so just in the second part of this page, it says, Part 2 does allow tailoring. And one of the things that, we would really like in the future is to hear from you about what further rights you have or you would like. So, please, make sure that you understand the Act as it is now, but also keep in mind how you would like it to change in the future, what additional rights you would like to have too, and so that we can have a document that's really a living document which continues to change and continue to improve. Next slide, please, Salva. So that touches on this slide, talking ahead of my slides. The Act really is an ongoing development. It's not designed to be static. It needs to change. Like what we've seen in anti-doping in the last 5 years, we've seen big changes in anti-doping. We've seen the rise of whistleblowers and investigations. and that's changed the rules that we've had, but it's also changed the rights that athletes have. So what more rights do athletes have? What more rights do you want as an athlete? What more do ADOs, anti-doping organisations, think that they can do? And how can athletes help in that process? I think the ombudsperson will change this space, especially in relation to remedy. And we really do need your input to help develop this further. Like, we've got it to this stage, but the more we hear from athletes, the more we hear about issues and concerns and the rights that you want and what is affecting you in your sport and within anti-doping, the further we can develop this and move this forward and make sure that everything is working better for athletes. Next slide, Salva. The benefits of the Act. I just wanted to touch on this near the end. So the benefits of the Act, and I think it's important that we talk about this briefly. So athlete rights are articulated, protected, and accessible. And I actually think that's a really big step forward. Instead of having our rights scattered amongst thousands of pages of documents, now in one place we have our rights. They are protected. So the Athletes Act is a document which WADA has to maintain. That's set out in the code, and also in the code, in the fundamental rationale for having the code, we now have athlete rights as a point there as well. So this is a document that exists now, and it will continue to exist, and it's protected in its two parts by how it's laid out in the code. And because we have these rights and because they're articulated in one place and accessible, I really hope that improves athlete confidence in anti-doping. Sometimes one of the things that we've heard from athletes is that anti-doping is just making me do a lot of things. There's a lot of rules that I have to follow, and hopefully now, by making these rights accessible, it helps athletes understand that there's a bit more balance in the system. And hopefully it also leads to athletes and anti-doping organisations working together. Because as I said earlier, like, if we're on the same page, if we're trying to achieve the same goals, get to the same place, which is clean, fair sport for everyone, and we all can play our part in that, and we can all contribute to the system, we all have confidence in the system because we know what our rights are as well as our roles and responsibilities are, then we can continue to improve it together. So if athletes have protections and they want the anti-doping system to work, and ADOs want the system to work, then we can improve things together and get clean sport together. So that's, I guess, some of the overarching goals of this. But it's important to know that the Act is there and that these are your rights that are articulated in it. So as I said, it's we would love to hear from you, and we want this to be a document which moves and changes to the times and to best represent athlete rights. So please contact me. That's my email address. And if you want to reach out to the wider athlete committee also on maybe not even athlete rights, but on any other issue with an anti-doping, please contact us. We're more than happy to hear from you. And the more we hear from you, the more that we can help and try and improve your experience of anti-doping. So now I think that's my presentation done. Sorry to have spoken for so long. And Stu, are there any questions?
There are, Ben. Thanks very much for your comprehensive review of the Act. There aren't a lot of questions, so please feel free to post some in the chat if any of you have questions. First question, Ben, is whether the Act is or will be available in Spanish at any point.
Yes, I think so. It's on the WADA website at the moment in French and English. And Stu, maybe you can answer that one. I think the answer is that it will be. It's definitely something that we're looking to do. Now that it's all finalized, we will look to make it available in Spanish as well. Yeah, and on that, for everyone else, I was having a discussion today, and I think a lot of anti-doping organisations are looking at translating it within their own countries, and that's something that we're definitely encouraging them to do. So our hope is that it will be translated into many languages.
Another question, Ben, with regards to Article 17 and the right to legal aid, how do you see the ability to access financial support for such legal aid? How do you see that working?
Yeah, that's an interesting one, and it really depends on where the anti-doping organisation is. It often depends on the rules of the anti-doping organisation, whether they can even offer legal aid, or whether legal aid is offered by a third party, which the anti-doping organisation merely sort of refers the athlete to. So I think what we'll see is that in different jurisdictions around the world, it actually operates in quite different ways. Some countries, the hearings are free, in other countries they're not. And one of the issues that we have is that there is this real big imbalance around the world of what you pay in different jurisdictions, and so what we're trying to do is even that sort of global system out a little bit. And so we've made the proposal on legal aid. Like, we obviously want to reduce the cost for athletes as they go through the process, but the end result might still be that process looks quite different depending on where you are.
Okay. Another question is, how frequently will the Act be reviewed and updated?
Oh, we can review it all the time. Yeah, if an athlete comes forward and they have a really good idea, if we're seeing a change within anti-doping, like the changes that we've seen around whistleblowers and investigations, then we'll have to update the Act accordingly. I guess fundamentally it will change the next time we do a code review. That's when we go through a major process of looking at anti-doping rules and international standards. So it'll definitely happen then. But I hope that it's more of a living document than that, and that in the coming years we can also adapt it.
The next question, I think you can answer as much wearing your code drafting team hat as your drafter of the Act hat. The question here about the rights for those who come forward as whistleblowers, and how do we ensure that they're protected adequately, especially, of course, if they are an athlete themselves?
Yeah, let me just finding the right section. Yeah, so what the code does now is that it allows for someone who is threatening or intimidating an athlete to prevent them from coming forward. It allows them to be sanctioned. At the moment, that isn't there, and so what we're saying is that if I wanted to come forward and I had information and Stuart here was threatening and intimidating me, then he could be charged with an anti-doping rule violation and therefore banned from sport. And so that in itself is quite a big step forward. And anti-doping organisations are also working hard to make sure that there are channels for athletes to come forward in an anonymous way. So WADA has the Speak Up platform, so athletes can contact that, and they can be confident that it's confidential. And then on the other end of that, they can have confidence that if someone does threaten them or intimidate them, then that person can be sanctioned as well. So hopefully, because that person can face further consequences, hopefully they won't act in that way.
Thanks, Ben.
Hopefully that answers that.
There's a few people that are asking about whether it's possible to translate the document into other languages. So I would just say, as is the case with many other WADA resources, we need to partner with other anti-doping organizations to help us with that. So certainly, if you have an interest in having the Act made available in the country of your, in the language of your choosing, please don't hesitate to get in touch with Ben and myself, and we'd be happy to work with you on. Well, we would need your help with the translation, but certainly making available, a word-based document, for example, so that it's there. Furthermore, there was also a couple of comments or requests, Ben, for your time for additional talks and webinars with smaller populations. So for those of you that have posted that in the chat, I just encourage you to contact Ben directly at the email address that you see on your screen. And then perhaps one of the last questions I see, Ben, is there's a question around whether it's a suggestion or a requirement that anti-doping organizations compose athlete committees or commissions.
It's just a suggestion. And this is in some ways similar to legal aid, and anti-doping organizations are set up in quite different ways around the world, and they're often set up by a government passing legislation. And so as a requirement of that often sets out what the governance structure is going to be. So sometimes it's quite difficult for anti-doping organizations to change their governance or how they work. And so what we're trying to do as the WADA Athlete Committee is we're sending out a survey early next week to anti-doping or to NADOs and RADOs to get a better understanding of what athlete representation they have at the moment and who has athlete committees and if they're appointed or elected. And then what we're sort of envisaging is that there might be sort of a range of best practices that we put out to anti-doping organizations to say, maybe an athlete committee is the top one, maybe having athlete represented, like a smaller group of athletes from particular, high risk sports or across a broad spectrum in your country. Maybe just having the last model might be, I don't know, consulting with athletes via a forum or something that you hold yearly. So we need to work through that as the athlete committee, but it is something that we're not demanding. It's just something that we think is best practice, and that we would really like to see anti-doping organizations increase their athlete representation and athlete voice.
Thanks, Ben. So I think I've captured most of the questions here. I apologize if I've missed any, and if any of you haven't had your questions responded to, I just encourage you to follow up with Ben directly. Before I let Ben close the session, I'd certainly like to thank everybody for joining us this afternoon and encourage you to contact us if you have more questions or would like more information. I'd also like to thank Ben for his time this afternoon and his commitment to this act and this initiative. I know Ben also has a short video he'd like to show us. So again, thank you and best wishes to all, and I'll pass back to Ben to close.
Thanks, Stu, and thanks for moderating the questions and doing the introductions and helping out. And thanks to Salva, who's running the technical aspect of this behind the scenes. And to everyone out there, wherever you are in the world, I hope that you're doing well this year. Thank you for listening to us today, and I hope you found it informative. The Act is on the WADA website in French and English. And if you have any questions about it, please contact me. Hopefully you have my email address. And we now have a short video that we'd like to show you. And following that, you'll be sent a questionnaire about the webinar. So thank you very much, everyone.
The purpose of the World Anti-Doping Program is to protect the athlete's fundamental right to participate in doping-free sport. Making sure that athletes have rights under the program, that they are aware of those rights, and can exercise those rights is vital to the success of clean sport. Over 2.5 years and in consultation with thousands of athletes and stakeholders worldwide, WADA's Athlete Committee developed the Athletes Anti-Doping Rights Act.
We're incredibly grateful to all stakeholders and athletes that contributed to developing the Athletes Anti-Doping Rights Act. It's vital that athletes and anti-doping organisations understand the rights that are in the Act and the remedies that are available. We now call upon all the anti-doping organisations and athletes to implement the Act and its promise. We really hope that this will become a valuable resource to everyone within anti-doping.
WADA is an athlete-centered organization, and everything that we do is to protect athletes' right to access clean sport. I applaud the Athlete Committee's efforts in developing the Anti-Doping Rights Act, which helps ensure that athletes are aware of their rights and can exercise them, which is vital to the success of clean sport.